Welcome to Linda Liu IP course. This is Fei Shan. Today, let's talk about how to avoid or reduce the access claim fee for patent application in China. A foreign patent application may enter China via PCT or the Paris Convention. Since the CNIPA charges the access claim fee differently for applications via PCT and applications under Paris Convention, the applicant may employ special strategies for applications entering China through the two paths, so as to reasonably avoid or reduce the access claim fee. Furthermore, regardless of the access claim fee, by making full use of the opportunity to making voluntary amendments, it is possible to benefit the subsequent examination and gain a more desirable scope of protection. 1. Foreign patent application enter China via PCT. According to China's practice of patent examination, the access claim fee for a PCT application enter the Chinese national fees is determined based on the number of the original claims of the PCT application. Generally, amendments made in the subsequent stages, including amendments made under Article 28 or 41 of PCT upon entering the Chinese national fees, or voluntary amendments made within the period for making amendments on the applicant's initiative, such as cancellation or addition of claims, will not generate access claim fee. Furthermore, an increase or decrease in the number of claims at the patent granting stage, as compared with the number of claims upon filing, will not generate additional charges. Therefore, for a PCT application enter the Chinese national fees, the access claim fee mainly arises from excessive claims of the original PCT application. The access claim fee will be charged in a case where there are more than 10 claims. The charges for a PCT application vary from the international fees to specific national fees. The applicant often considers the processing of a PCT application in light of the examination in the possible designated offices and the fees charged in these offices. The access claim fee charged in the PCT national fees of China is different from that of all the other countries. If the applicant intends to avoid or reduce the access claim fee in the Chinese national fees or wants to make a full use of the PCT national entry period for making voluntary amendments, even if the access claim fee cannot be avoided or reduced, the following is a feasible strategy. At the stage where the PCT application is still being drafted and will possibly enter the Chinese national fees later, the applicant may consider reducing the items of claims in drafting, so as to avoid or reduce the possible access claim fee. For example, it is preferable that the international application document is drafted making use of multiple dependent claims depending on preceding multiple dependent claims, and claims incorporating multiple preferable technical solutions or coordinate technical solutions, thereby covering as many technical solutions as possible in the scope of protection while avoiding or reducing the access claim fee. Alternatively, the international application may only include a limited number of items, for example, 10 items in the claims, and completely disclose the other technical solution desired to be protected in the specification. As such, upon entering the Chinese national fees or in the period for making voluntary amendments, it is possible to incorporate the technical solution described in the specification into the amended claims, thereby avoiding or reducing the access claim fee while including the technical solution desired to be protected in the claims pending for examination before the substantive examination starts. At the stage where the PCT application has been filed with the receiving office and not yet entered the Chinese national fees, the applicant may apply in the subsequent stages of the strategy described below. Because the number of claims included in the international application has been determined, in other words, whether the access claim fee will be charged has been determined. In a case where the claims of the original PCT application include excessive items, the applicant may consider reserving the original claims till the examiner issues an office action, because even if some claims are deleted, the access claim fee and the examination fee will not be reduced. Usually, unless the application has the defect of lacking unity, the Chinese examiner will conduct a substantive examination based on the reserved claims, which increases to some extent the efficiency of the applicant in responding to the OA. In a case where the claims of the original international application includes only a few items, but the applicant wants to include more technical solutions in the scope of protection, the applicant may first consider adding claims, independent claims in particular, upon entering the Chinese national fees or in the period for making voluntary amendments. In such a case, no additional charge will be generated. Furthermore, the aforementioned two timings are the best opportunities for adding independent claims. It will become very difficult to add independent claims at any time other than these two opportunities. Please note that there are indeed limits on the number of items allowed to be added at the aforementioned two timings. If excessive claims are added, such as exceeding an extent acceptable to the examiner may require the applicant to pay an excess claim fee in view of the corresponding precedents. If the applicant wants to add quite a few claims while intending to avoid paying an excess claim fee, as an option, the applicant may consider preferentially adding independent claims upon entering the Chinese national fees or in the period for making voluntary amendments, and adding dependent claims in the OA period, because adding a proper number of dependent claims in the OA period will not greatly increase the work of the examiner and is thus more acceptable to the examiner. However, if a dependent claim is of great importance to the applicant, it will be more prudent to submit the amendments involving the dependent claim before the time limit for making voluntary amendments. The amendments involving dependent claims could be declined by the examiner under the guideline for patent examination. In such a case, in order to protect the technical solution of a dependent claim, the applicant will have to file a divisional application. 2. Foreign patent applications enter China via the Paris Convention. According to China's practice of patent examination, the access claim fee for an application enter China under the Paris Convention is determined based on the number of claims upon filing. The access claim fee will be charged in a case where there are more than 10 claims. For a patent application enter China under the Paris Convention, the same strategy may be adopted as a PCT application does in the drafting stage and the stage of entering the Chinese national fees, in order to avoid or reduce the access claim fee. That is, the number of claims should be restrained. For example, within 10 items at the stage of drafting and filing, a suitable number of claims, in particular independent claims, may be added by voluntary amendments. A limited number of dependent claims may be added if necessary in the OA period. I hope this information will be helpful, and thank you so much for your interest and attention. If you have any questions, please feel free to contact me. See you next time!